Welcome to Case Flash, brought to you by the CBA Family Law Section. I'm Sam Schoonmaker, and with me today are Judge Linda Monroe and Attorney David Griffin. The Case Flash today addresses the new child support guidelines and significant developments in how practitioners handle cases involving child support. The first question is to you, Judge Monroe. What are the guidelines and why do they exist?
Well, approximately 20 years ago, the federal government told all of the states that if they were going to continue to receive subsidies for their child support courts, in our case is our magistrate court, they were going to have to establish child support guidelines. And that is why we have guidelines, and we periodically review them as required by the federal government.
What is the philosophical underpinning behind the guidelines?
The child support guidelines are based on what's known as the income shares model. That's a model that utilizes economic studies of intact families. Income shares is the most commonly used basis for child support in the United States. What it does is it studies intact families, and the conclusion of the income shares model is that at low incomes, low levels of income, families tend to utilize a higher percentage of their income for the purposes of their children's needs. And the higher income families spend greater dollars, but those greater dollars represent a lower percentage of the family's income.
Judge Monroe, what are some of the biggest developments that came out of this new revision to the guidelines?
Well, a major development was an articulation and explanation that has to do with the deviation criteria for shared custody. The first thing that the Guidelines Commission did was clarify the definition of shared physical custody to indicate that it means when a child is with a parent, it's also with the other parent for a substantially equal amount of time. It doesn't have to be an exactly equal amount of time. It must be a substantially equal amount of time. Also, the Commission decided to leave intact the previous explanation that the Wednesday overnight or Wednesday dinner and alternating weekends is not substantially equal time. Taking that articulation of the definition, the Commission then went on to say that an additional deviation criteria can be when parents who have shared physical custody under this definition have substantially equal income. There can be a deviation from the child support presumptive amount. Finally, in regard to this, to come to the proper presumptive child support, practitioners no longer have to guess who the proper custodian is when there's joint custody. Instead, the calculation is done based upon the greater incomed parent, that is, the parent with the greater income is the parent who would be paying the child support, and then the deviation criteria is applied therefrom. And that's it, Sam.
Attorney Griffin, what are some of the more significant changes that you see coming in the guidelines?
Sam, one of the things that I want to point out to practitioners is that the Commission clarified that incentive-based compensation is included in gross income. The definition of gross income is included in the definitional section under subsection 11, and it states right in there that profit sharing, deferred, and incentive-based compensation and severance pay are included. If the practitioner will turn to the preamble on page 2, Romanet 2, you'll see that it says incentive-based compensation such as stock options, restricted stock units, and other forms of delayed or deferred compensation, if and or when vested or exercisable, is clarified as being included in gross income. That's important because an ever-growing number of employees are being compensated not only with cash compensation, but with stock or other types of compensation that vest years in the future. So while they may be awarded in 1 year, the actual economic value only comes in future years. And there had been some uncertainty or debate among the practitioners about whether that should or should not be included. And the Commission in this instance clarified that all of that is included at the time it vests or is exercisable. Sam, the other part that I wanted to talk about are the high-income families. The guidelines right now have a $4,000 per week net combined income as the highest level that the guidelines cover. At the time the Commission was doing its work, we asked the economist who was doing the underlying study to see whether or not there was economic data supporting actual guideline chart numbers that would apply above $4,000. The economist reported to us that there was really no dependable data above $4,000, so that's the fixed number that remained in the guidelines, the same as before. What happens now is that the Commission clarified or put in language that removes any doubt that an above $4,000 net per week number as combined income, the $4,000 figure has boxes that show for 1, 2, 3 children what the child support would be. That dollar amount is now the presumptive minimum amount of child support that shall be paid by a parent. If the parent nevertheless has income well above that range, there's also now a maximum amount that should be the presumptive amount, and that is the parent's income times the percentage shown.
Is that more or less consistent with Dowling?
It is consistent with Dowling, and it is consistent with, and it will help practitioners to understand this is a way to frame the conversation. Of course, the judge, the trier of fact, is going to need to, and in any above $4,000 net weekly income calculation, refer to the statutory criteria in 46B 84D regarding what children's needs and how they need to be included in the calculation.
So the practice pointer, I think, for practitioners on this is there's a minimum presumptive support amount, there's a maximum presumptive support amount, and if they want the judge to deviate or go above the maximum, they had better be well educated in what 46B 84D is and the other deviation criteria.
I think you're absolutely right, and I really think that the practical effect of this is as soon as you're above that $4,000 per week combined net weekly income, you're going to have practitioners putting in as evidence all of the 46B 84D factors.
What do you think that'll do to the length of hearings?
I think it'll increase the length of the hearings on those types of cases. On the other hand, the legislature has said that a child support calculation necessarily must identify the needs of the children, so it's an appropriate way to proceed.
And it's a relatively small group of cases in terms of numbers of cases. They may take a lot of court time.
No doubt.
Judge Monroe, what are some of the components of a child support award?
Well, a child support award has a variety of components, and this is a good segue to the other part of the population of the state of Connecticut, and that is where awards exceed 55%, there are new guidelines regarding that. When a child support order is entered, we think of it traditionally as only the child support order and perhaps the arrearage, but it also includes a health insurance order. It includes an order in regard to health expenditures that are not paid for insurance. If the custodial parent has to pay for daycare to work, it includes an award for that. And it may, from family to family, include an award for extracurricular activities, which under these guidelines are explicitly not included as part of the guidelines child support amount. In some families, people who work very hard but don't necessarily earn a lot of money, all of these components, when added together, may exceed 55% of the payor's net income. The Guidelines Commission determined that if that occurs, there should be a deviation criteria which allows the payor to ask the court to deviate from certain components of the child support order to reduce that that whole amount to something less than 55%. The one piece that can't be reduced is the current child support order. So if you look at your child support guidelines worksheet, at the very bottom you will see that now the computation must occur so that the court knows whether they are brooking that 55% number. That's a major change for some of our families in Connecticut.
Do you see any other significant differences between these guidelines and the last set of guidelines?
Well, Sam, another one of the changes that I think practitioners should be aware of is the fact that alimony, which used to be part of the calculation, has been removed in the current guidelines. I'd refer practitioners to the definitional section of net disposable income, 46B-215A1, subsection 17. And practitioners will notice that a former section that allowed credit for 80% of an alimony payment in the context of calculating health insurance, unreimbursed medical expense and child care expenses has now been removed. The upshot of that is that the Guidelines Commission felt that the most important thing that needed to happen was that child support needed to be first in the calculation, and alimony was really something that shouldn't affect the calculation at all. Just to be clear, this then affects what's known as net disposable income. So if you look in the guidelines worksheet and you work down through a party's gross income, their deductions, and you get to each of their net incomes, when you then work down the chart, there's a child support amount that is paid by the non-custodial parent to the custodial parent. After that payment is made, you then have a movement of money from the non-custodial parent to the custodial parent, and that then results in net disposable income. It was from that number that you were allowed a deduction formerly for alimony. That's been removed.
Since you were describing one of the reasons the Guidelines Commission did this, my memory is that the preamble explains as well that the Guidelines Commission noted that alimony is explicitly under our law is spousal support, and child support is support for the children, and the two should not be conflated with each other.
Who writes the preamble? The preamble says it is separate from the guidelines. Who actually writes the preamble?
The preamble is written initially by certain members of the commission. We created a subcommittee for the creation of the preamble. And then once the preamble was written with great care, going through all of the changes that had occurred in the guidelines themselves, the entire commission then pored over the preamble, the new preamble, in order to be certain that the preamble reflected the thoughts of the commission and the changes contained in the guidelines.
I think it's fair to say this commission, as it went through major votes, was very aware of the preamble and directed itself to consider changes, explanation within the preamble, because the Supreme Court has in recent years cited to the preamble as if it is law rather than mere explanation. And therefore, you may find that the preamble is maybe more exhaustive than it's been in the past, but it's responsive to the Supreme Court's decisions, since the Commission felt it was then their responsibility to be very clear about why they were doing what they were doing.
Right. Maturo, in other cases, cited very specifically to the preamble. Is there anything on the arrearage calculations that's different under the new guidelines?
Indeed there is. Thank you for bringing it up. There comes a time when children age out finally, and if someone still has an arrearage and is no longer paying a current child support order, under the old guidelines, the person would then be paying 50% of their, up to 50% of their old current support order to pay off the arrearage. Now, that number's been changed to 100%. The logic behind it is that a court had found that they had the ability to pay the 100% current support order, so the same number of dollars should be used to defray an arrearage that the payor had been ordered to pay but failed to pay. The payor may have extreme circumstances that require relief from that, and there is an avenue under the guidelines for relief from that.
Sam, I'd like to add something about supplemental orders. I didn't mention it earlier, but there are times when parties are compensated both by way of a regular salary as well as a bonus. And sometimes those bonuses are not the same. In fact, there may be times when a person doesn't receive a bonus. Nevertheless, when a bonus comes along, it should be included in the calculation to benefit the child. The Commission felt that when there is a compensation of indeterminate amount, such as a bonus, that the proper way for the court to handle that is to enter a dollar amount order based on the regular and recurring income, and then the court is authorized to enter a supplemental order that would be a percentage of the indeterminate amount, a percentage of the bonus, that would be paid if and when that bonus is paid.
Is that with the same limitations, with the maximum guideline percentage?
It would always be limited by the fact that there are parameters that must not be exceeded without some sort of a deviation.
It, however, would be considered a current support order, Sam, in the context of a 55% maximum. The reason the Commission did this, as David said, is sometimes parts of people's income is indeterminate, and that cuts across all socioeconomic strata of our state. And it's to save people having to come back to court for, say, seasonal employees, for having to come back when a salesman has a particularly good or a particularly bad year, or a salesperson, excuse me. And this hopefully will allow the court to do what has been happening somewhat informally already and save people time in court.
These are very significant changes to the day-to-day practice of family law. Anyone who has a child support case has to know these guidelines. It's fertile ground for appeals if they're not applied correctly, and the appellate courts do take the guidelines very seriously and examine these cases very seriously. So they're important. Thank you for watching Case Flash.